original draft plan allowed for flexibility for when this phase ultimately developed. It allowed for the potential to have low density or medium density residential. But when the zoning bylaw 02-22 came into effect and designated the land R6, it took away that flexibility to have low density residential. And right now the market demand is really for the single detached dwellings. And so we'd like to change to R4 to allow for that, or semi-detached. And we think it would be consistent with the current aesthetic of the neighborhood and would better blend with the existing residential along County Road 2. So if you have any questions or thoughts, I can answer questions.
Any questions of council for Caitlin? Yes, sir. Go ahead.
Through your mayor, thank you. I'm just looking at the draft plan of subdivision here, and when I look at the legend, I'm a little confused with the legend because there's two symbols that are quite close to each other, and then one's like a checkerboard. Could you just explain to me, please, where? Again, I don't have my glasses on, but there's one. I guess it's semi-detached apartments, and then the other one is, I guess, just single detached houses. Can you explain to me where the apartments are? There's no apartments going to be in here now?
Correct.
Okay, so what on the draft plan it shows it, so that those ones will now become what?
Would be single detached dwellings.
Single detached, okay.
Mm-hmm.
All right, fantastic, thank you.
Okay, thank you.
Thanks, Councillor Pennell. Any further questions? Michael, have we received any feedback from the public on this application? Yeah, okay. So I like the reasons why. I mean, it is certainly fitting. Does it really meet some of our housing needs? Perhaps not. But it is, I think, good use of the property, as you say, as you get closer to Highway 2, it'll give a good flow to it. No further questions? Thank you very much. Sorry, Councillor Richardson?
I'll just make a comment. I did have an inquiry about it, and the person that inquired was quite happy to hear that it was going into a single dwelling as opposed to building up. Mm-hmm. So thank you for that.
Okay, good. I'm glad to hear that.
I think just about anybody in that subdivision would be happy for it, because some of them have been there a long time. No, that's good. Thank you very much, Caitlin.
Thank you.
If there are no further questions, I would then look for a resolution to adjourn the public meeting, please. Deputy Mayor Kaiser, Councillor Richardson, all in favor of that motion? Motion is carried. Presentations. There are no presentations this evening. Deputations, Mr. Cowle and Mr. McPherson would need to come into the room, please. Oh, okay. For those that are watching live stream, we've got some sound problems, so we'll just wait for a minute, please. No, it's okay now. Oh, it's okay now, thank you. Good evening, Mr. Cowle and Mr. McPherson.
Good evening, everyone. Your Worship, members of council, thank you for the opportunity to speak to our client's application for validation this evening. Our client is a local family-owned corporation owned by the McPherson and Gordon families. It was responsible for one of the town's most desirable neighborhoods, the Edgewood Drive subdivision, and the president is currently Bruce McPherson Jr., who's with me here tonight. In the early 1970s, as the province began to regulate the subdivision of land, developers rushed across the province, creating subdivisions by surveying and alternating ownership between the lots before the expense of developing subdivision plans were mandated. Such a configuration was done south of Napanee on the west side of County Road 8. 29 lots were laid out with streets deeded to the former North Fredericksburg Township, running at 90 degrees off of County Road 8. Our client bought this development from its creators as a long-term investment, but they had no idea how long. Our client maintained the lot separation by using the shareholders as trustees and then the corporation as alternating owners. For about 45 years, they've paid taxes on all these lots based on their values as building lots. Before his death, Bruce McPherson Sr. discussed development ideas with planners and the town, and we still could not come up with a viable solution that was economical. After the deaths of Bruce and Eileen McPherson and Chubb and Rita Gordon, the remaining family put the property up for sale with no takers for years. As it was clear that the little streets and lots would not be developed in their present configuration, the town was approached to close and reconvey the streets and the lots so that the lots could be consolidated together with the streets. Years ago, the company lawyer Bruce Zarin had obtained signed deeds from the shareholders to the company to reconvey the lots if necessary. These deeds were suddenly useless to us as the provincial policy for using paper transfers by the Director of Titles didn't allow us to use them anymore once the electronic system was fully implemented. So, in order to avoid the administration of the 4 estates of the 2 McPhersons and the 2 Gordons, it was possible for us to obtain a judge's order to consolidate all the personally held lots into the corporation. However, there were 2 lots along County Road 8 that were viable, lots of record on which residential construction could be able to be done and would be in keeping with the lot sizes of most residences in the vicinity, as you can see from the parcel map that I sent along. Our client has been a solid, if not over-generous, contributor to the tax revenue of the town for nearly half a century with these lots, and seeks your assistance in being able to preserve the viability of these 2 lots as basically seed money to tackle the great expense of professional planners and engineers necessary to develop the remaining large parcel, which is so handy to the new school and would appeal to young families. The Planning Act requires new land development to go through a process of approvals known as consents or severances for individual lots and plans of subdivision for multiple lots. This is why our official plan indicates that the validation process is not a substitute for these processes. Before province-wide regulation, people could divide their land as they pleased. The Planning Act prohibits someone from transferring land if they retain any land that abuts or touches the land being sold. It makes such a transfer invalid. The problem with this formulation is that many times people acquire land that was always in separate ownership and taxed separately and find that they've unknowingly, in many cases, welded their parcels of land together. In the early years, the courts had to consider cases under the Planning Act, and everybody referred to them as the bear trap cases, because people were trapped by rules they had no idea would reconfigure their lands and force them to obtain surveyors and lawyers and pay municipal and planning fees to reestablish well-established boundaries. However, there's a section in the Planning Act that is a remedial section that can be used in the discretion of the municipality to validate which would otherwise be invalid conveyancing. It's a principle of statutory interpretation that remedial statutes be interpreted broadly. As indicated in the materials that I've circulated from experts on the Planning Act, the use of Section 57 of the Act only requires council to consider if the land conforms to the official plan and zoning bylaw. The Act does not use the words comply with the current zoning regulations. It's a broader term, conforms, which I invite council to differentiate from compliance. You'll note in the town's zoning bylaw definition section the difference between non-complying and non-conforming. Non-complying means a use, building, or structure which is listed as a permitted use in the zone where it's located, but which contravenes one or more of the provisions of the bylaw applicable to the zone in which such use, building, or structure is located, compared to non-conforming, which means a use, building, or structure which on the date of the passing of the bylaw was not listed as a permitted use for the zone in which the use was located. Conformity relates to use, not dimensions. The subject parcel is vacant land, which is a use that conforms. This parcel of land and the second one that would be created fall within the exception in section 410 of the Greater Napanee zoning bylaw, which deals with existing undersized lots and reduced frontage. It says, where a lot having a lesser lot area or frontage than required is held under distinct and separate ownership from abutting lots shown by conveyance of title in the records of the registry office on the date of the passing of this bylaw, or where such a lot is created as a result of expropriation or acquisition of land for public use, such smaller lot may be used and a building or structure may be erected, altered, or used on such smaller lot, provided that A, all other applicable provisions of the bylaw are complied with, B, existing lots to be developed on private services, well and septics, shall have a minimum lot area of 1,390 square meters. These lots have 1,393, and 20 meters of frontage. These lots have 30.48 meters of frontage. And C, approval is obtained from the appropriate regulatory agency for the sewage disposal systems, and B, potable water is available. It is council's own interpretation of their planning documents that governs, and there's no right of appeal. There's not likely anybody willing to apply to Superior Court to quash your bylaws based on a reasonable interpretation by you of your own bylaws. The lots that would be reestablished by the validation order conform to the zoning bylaw because they were lots of record, essentially grandfathered pursuant to section 410. The reestablishment of boundaries collapsed by inadvertence or necessity, as in this case to consolidate with other lands, is not new development, and council's free to use its power. There's no requirement in the Act or the regulations indicating that the transfer requiring validation be intentional or accidental. Your planning report makes emphasis of this as if it were a criterion, but it's not. More often, it's the conveyancing immediately before the transfer that needs validation, which was inadvertent. Parcels had inadvertently become merged together, but existed as lots of record and were taxed as such. Otherwise, a consent would be the appropriate means to establish new boundaries rather than restore old ones inadvertently lost through the bear trap. There's also no requirement in the law that transfers of lands that are subject to validation under section 57 be in a certain state of development. Your staff report notes this and the issue whether the transfer being validated was inadvertent as justification to reject the request, but there's no basis for these criteria in the Planning Act, the regulations, or the official plan. The staff report also makes reference to the location of the Trans-Northern Pipeline. The right-of-way for the pipeline is 60 feet wide, and of course the pipe itself is significantly narrower than that. As part of the development of the lot affected, the owner will have to secure either encroachment permits or lot additions from adjoining lands to deal with the pipeline. That's on their radar and will be properly addressed. The essence of this request is that there's been 2 viable building lots of record out of 29 that the applicant has paid tax on for 45 years. These lots are legal under section 410. They're in character with most of the area and will quickly generate more tax revenue from the town if they can be used now rather than being part of a whole new costly process that may be years getting off the ground. It took months and thousands of dollars to bring this request to you. Please consider your wide latitude that you have to grant the request for the validation certificate, which in my submission benefits the town faster as well as our client. Thank you for your time this evening.
I just wanted to say a couple of things. I think you can appreciate why I had to have Bruce here tonight. That's fairly complicated, but I'm just very anxious on behalf of my own family and brother Tim, and certainly the Gordons to get some closure to this. It's gone on for a long time, and I hope you can see us through that. That's all. Thanks very much for your time.
Thank you. Michael, did you wish to speak to this now? Do you want to leave it until your next section, or does council have any questions that they want to start the discussion with? So I'll let council start first, but before I start, and I'm going to show my age here, when this, what we call checkerboard subdivisions came along, I would hate to tell you how long Janie Alkenbrack and I worked on that absolute file to work through the night to get those registered on time. So kind of interesting that it's coming back now. Councillor Pennell.
Thank you, through your worship. Mr. Cowle, may I call you Bruce?
Absolutely.
Thank you, Bruce. Bruce, you answered one of the questions I had, which was in regards to the pipeline going through. One of my questions regarding that is why would you not just leave it as one lot if you have to go through the measures of looking for encroachments or maybe taking land from another property to be able to use that? Why would we not just leave it alone and have a 200-foot wide lot?
The existing legal descriptions describe them in individual parcels and they're taxed with different roll numbers. One of their options may be to consolidate it north-south, which would make it out of that one lot, but it's still, the northerly parcel is totally unaffected by the pipeline, so that to get, if they need additional land, they'll go back. They'll go deeper to the west or to the south, so that the other northerly lot would be unaffected.
Okay, thank you, and worship, one more if you don't mind.
Certainly, yeah.
Okay. My question too, Bruce, would be why if these two are abutted, and I fully understand what happened here, but why didn't they merge in with Part 1 on R90, which is right in the corner where you have it, all of the checkerboard, if you will, where it's been consolidated? How come it didn't join there if it was in the same names?
So it actually did, and in order to undo that merger of the whole parcel, we did a conveyance of that, I guess at the southerly of the two lots on County Road 8. So that was a means by which we could create separation to reestablish the boundary by validation. It was, the moment the judge's order was issued and registered, it was one block.
Okay.
Yeah.
And that's why we're here tonight for this.
Absolutely. Otherwise, we'd be going through the consent process. But the logic was, these are established lots of record. We don't have to go through a process that's used for new land development when there's an alternative process.
I thank you for that, because now it just became clear. Thank you.
Yeah, Councillor McCormack?
Thank you, Worship. I'm just curious, the easement for the pipeline, when was that established?
Oh, the 1950s, I'm thinking?
Okay.
Yeah.
So after the initial purchase,
Yeah, so the original plans, I think that R90 that Councillor Pennell just mentioned, I think it shows, yeah. So the survey that created one of the batches of lands that's immediately adjacent to the ones we're talking about, it was surveyed in 1970 and showed what would be the north limit of the pipeline. So it was in place then.
all right, thank you.
Any further questions? If not, I would entertain a motion to note and receive, and then we will go right to, unless, Michael, you wish to speak to this to anything? Does anyone have any questions of Michael, I guess would be the best way to put this? Not at this time? Okay, so what I will do then is take a motion to note and receive on the deputation. Councillor Norrie, Councillor McCormack, all in favor of that motion? Motion is carried. Now we're going to move to 11.1, just for time expediency. And Michael, did you wish to come to speak to it now then, please? Thank you.
Through you, Your Worship. Can you hear me okay?
Yes, sir.
So staff received this request and circulated the materials to the municipal solicitor and our planning consultants to review the file. Ultimately, the recommendation was to deny for the fact that when the lots were merged through the vesting order that Mr. Cowle spoke about, there was then the transfer of the more southerly lot, which was not in compliance with the Planning Act as per our municipal solicitor's comment. So it was that intentional contravention of the Planning Act that staff cannot support. However, ultimately, it is council's decision. If you wish to provide the validation, it is ultimately council's decision. However, staff are not able to recommend approval due to that intentional contravention of the act. Once the lots were merged, there was an intention to convey the southerly lot, which was not permissible. And that's what landed staff at the recommendation before you tonight.
Council, questions of Michael for this? Councillor Canal?
Through your worship, I think that was one of the questions that I just asked Bruce for clarification on it. And because of that transfer is the reason why we're validating now, instead of going through a consent.
Correct.
Yes, okay.
That's correct.
When I did my research on this, as we heard earlier, all of those lots along that stretch are all of the same road frontage of 100 feet, and the depth of 150 or a little bit more. So I think that I still have some concerns with that pipeline going through there, but if it's on their radar and they're going to do something with that, then I'm fine. I appreciate it. Thank you.
Any further? Councillor Richardson?
Just briefly, Your Worship, so this lot, even with the right-of-way and the pipeline, it's still big enough to build a house, put the septic in and all that kind of thing?
Those are questions that staff have. We've not seen any proposal for what is likely or planned to go there. The sketch was supplied to staff, but there's no preliminary plan of where septic is proposed to be located in a house. So we don't have a lot to go on at the moment, but it does appear that as though there may be a smaller sized house that could fit. It might need to encroach on the easement,
Yes.
Which could be addressed, as Mr. Cowle mentioned, but it would be tight, certainly.
Okay, but I guess what I'm saying, it is possible. From the picture, it looks fairly daunting with the easement and the pipeline, but again, it's very difficult to tell from the picture whether there's enough room there to put a house and everything in. But I'm guessing that there probably is.
There likely is.
If it's situated correctly?
Correct, that's
Yeah.
correct. Yeah.
Okay, thank you.
So I guess I want, any further questions from council? So I guess just so that everybody's on the same footing and understands, if we are to deny this, where does it put the applicant?
If council were to deny, the applicant would have to apply to the Committee of Adjustment through the consent process to create the lots.
And if we approve it?
And if it is approved, it's approved. There's no appeal mechanism. A third party cannot appeal it, and the lots go back as is requested.
So with this sitting the way that it is, does it remain what I'm going to call a checkerboard subdivision, or will there have to be a plan of subdivision that would have to be put on this to proceed with developing the land?
If the proposal is to only create the two lots as are proposed and requested through the validation order, there's no requirement for a plan of subdivision. However, on the larger southerly lot, which is highlighted in yellow on the material that Mr. Cowle presented, that would require likely a plan of subdivision depending on the density and how many lots are proposed.
So would the county, to begin with, allow entrance permits? Maybe it be a keyed entrance because they're so close together in short frontage? Or would they run into trouble getting entrance permits because it is a county road?
They may run into trouble just based on the severely reduced frontage. So current standard is 200 feet of frontage, just shy of 2 acres in area. So this is essentially less than half of that for both lots. So the county may have an issue with two very close entrances in that sense. It may.
But that's not our battle.
And it's not our jurisdiction. That's correct.
Okay. But really, when you look at all the other lots that are around there, it is a built up. It is strip development, but it is in keeping with the neighborhood. Okay. Council, you've got a decision. Another question,
No, I
Councillor?
just
Okay.
I just, through Mayor, I'd just like to make a motion that we go with the ask and we do, we validate this.
Okay. So you've, before you have received for information, validation request report and further that council deny, so you're not gonna take, staff recommendation, you're going to make the recommendation that we accept the validation or that we approve the validation, is that what you're saying?
Yes, that's correct.
Okay, I
Yes.
just wanna make sure. Seconded by Deputy Mayor Kaiser. Any further comments or questions?
I would.
Okay, certainly.
Thank you, Your Worship. Again, it's been stated, well stated again, the lots are in keeping with the rest of the lots up and down County Road 8 in that area. And, I mean, we've done similar ones. My only concern is the pipeline, and it may, or the easement for the pipeline, that it may interfere with future development or impact what possibilities are there, but I don't have a problem with that, and we certainly can't presuppose that at this point in the game. The county road allowance or entrance permits would be their condition, or our condition for them, but I support it, and it's very in keeping with some other ones we have done recently in other situations, so.
Okay, Michael, go ahead.
Just through your worship, just for council's consideration, if there is an issue with the pipeline and the easement encroachment, it's a possibility that there could be a consent to add more area to that lot if you know, situating a house is next to impossible with the current lot configuration.
Okay. Okay, yep. Anything further? If not, I'll call the question. All in favor of the motion? Opposed? Carried. Thank you very much. Thank you, gentlemen. Now we're going back to where we should be. Just so that I don't forget. So we need to get Mr. Key on the phone. Kenneth Key, 6.2. Thanks, Michael. And thanks, council.